Article 1390. The following contracts are voidable or annullable even though there may have been no damage to the contracting parties. Number 1. Those where one of the parties is incapable of giving consent to a contract. Number 2. Those where the contract is vitiated by mistake, by violence, by intimidation, by undue influence, or by fraud. These contracts are binding unless they are annulled by a proper action in court. They are susceptible of ratification. By the way, ratification will be discussed in other articles later on. So let's proceed. What is voidable or annullable? Voidable or annullable contract is a contract where breaches exist that can render the contract invalid. If it is believed that a contract was not made in good faith, it is up to the aggrieved party to decide if it is good or valid and therefore enforceable. A voidable contract will remain valid until the point that it is declared void once a breach has been determined. Voidable agreements can be rendered enforceable if the unbound party consents to give up their right to rescission. Contracts that are voidable include those involving prostitution or gambling. For example, Ali was asked to purchase Ella's car worth of 1 million. But when she refused, Ella punched her until she consented to do so. In other words, there was a threat. Please take note that the existence of economic damage is not essential for their annulment as in the case of rescissible contract.
Kinds of voidable contracts. A contract otherwise legal in object and operation is voidable because of a defect caused by, in other words, the contract is voidable if one of the parties' consent is faulty or vitiated. Number 1. Legal incapacity to give consent when one of the party is incapable of giving consent to the contract. In other meaning, legal incapacity consent only occurs when one of the party is unable to give consent to the contract. Number 2. Violation of consent when the vitiation is done by mistake, violence, intimidation, undue influence, or fraud. When entering into a contract, it's important to understand which contracts are voidable or annullable to the event of a certain circumstances. Let me give you some example of mistake. Feby signed into a franchise agreement of 2 million pesos. The clerk who made the sale entered 200,000 incorrectly. In this case, the clerk made the error, and Feby is not responsible for it. Example of violence. Anna demanded that Jessica sell her brownies or else she would punch Jessica in the face. Example of fraud. Falsely claiming that signing a purchase agreement of a cell phone entitles you to free cases and tempered glass for the duration of ownership of the phone. Remember, it's important to understand the implications when entering into a contract. Meaning of annulment. Annulment is a remedy provided by law for reason of public interest for the declaration of the efficacy of a contract based on a defect or vice in the consent of one of the containing parties in order to restore them to the original position in which they were before the contract was executed. Let me give you some examples. Marriages. There are void and voidable marriages. Example of void marriage. Joey and Erica are father and daughter, but they still insist to go for their marriage. This shows a incestuous behavior. Example of voidable marriage. When Marlon gets intoxicated, he constantly hurts Maria. So, if the physical abuse has increased, the marriage is voidable.
According to the Article 1391, the action for annulment shall be brought within 4 years. This period shall begin on the following. First, in case of intimidation, violence, or undue influence from the time the defect of the consent ceases. Next one is in case of mistake or fraud from the time of the discovery of the same. And lastly, when the action refers to the contracts entered into by minors or other incapacitated persons from the time the guardianship ceases. So let us discuss it one by one. First, in case of intimidation, violence, or undue influence from the time the effect of the consent ceases. So before the time of these, the consent is still being vitiated, and therefore the victim cannot be expected to bring any action in the court. For example, A was intimidated into signing a contract on January 5, 2017. The intimidation continued until December 5, 2017. So in here, the 4-year period of filing an action started on January 5, 2017 and will be ended on January 5, 2021. So next one, in case of mistake or fraud from the time it is discovered. This must be so because before the time of discovery, the innocent party is unaware of the reason that renders the contract voidable and cannot also be expected to bring an action in court. Furthermore, the guilty party should not be rewarded for successfully hiding the mistake or fraud. Also, the time of the discovery of the alleged mistake or fraud, it must be clear from all the allegations of the complaint. For example, B and C entered the contract on April 1, 2019. On April 1, 2020, C discovered that fraud was involved when she entered the contract. So for this part, C must file an action for the annulment of the contract within 4 years from the date when the fraud was discovered. Otherwise, C's right to sue for the annulment of the contract will be prescribed if C did not file an action at the said date. And lastly, in case of the contracts entered into by minors or other incapacitated persons from the time the guardianship ceases. So in this case, guardianship ceases upon reading the age of majority. An incapacitated person also has no capacity to sue. For example, D sold his horse to E, who's only 17 years old. Upon reaching 18 years old, he can avail an annulment of their contract within 4 years until his last day of being 22 years old. Otherwise, he cannot do so.
Article 1392. Ratification extinguish the action to annul a voidable contract. So first, let's define the meaning of ratification. Ratification is the voluntary adoption or approval of an illegal or flawed act or contract that would not be legally binding on the person without his subsequent permission or cooperation. It shows that the ratifier intends to be held accountable for the terms of the agreement. There is no more distinction between the following. First, to address an error in a voidable contract. Second, to remedy the lack of authority in a valid contract. Last, to make up the lack of evidence. For example, when a private instrument is turned into public document or an oral loan is put in writing. The effect of ratification. Action to annul is extinguished. Article 1392. Thus, the contract becomes a completely valid one. The contract is cleansed of its defect from the beginning. Article 1396. So this is the example. A contract can only be signed by those who are 18 years of age or older. Therefore, if someone wants to buy a car but only 16 years old, the deal could be legally voided. The person might approve the contract and honor the car purchase once they were the legal age to do so. Small business owners might have to approve agreements that were signed by the people who weren't authorized to represent the company in court.
Article 1393. Ratification may be effected expressly or tacitly. It is understood that there is a tacit ratification if, with knowledge of the reason which renders the contract voidable and such reason having ceased, the person who has the right to invoke it should execute an act which necessarily implies an intention to waive his right. There are two kinds of ratification. The first one is express ratification, where it is manifested in words or in writing. Implied or tacit ratification, where it is manifested by silence or acquiescence, by acts showing adoptions or approval of the contract, or by acceptance and retention of benefits flowing therefrom. The requisites of ratification. The requisites for implied ratification are the following. 1. There must be knowledge of the reason which renders the contract voidable. 2. Such reason must have ceased. And 3. The injured party must have executed an act which necessarily implies an intention to waive his right. Example: X, a minor, sold his land to Y. Upon reaching the age of majority, X, with full knowledge of his right in the premises, instead of repudiating the contract, disposed of the greater part of the proceeds, or collected the unpaid balance of the purchase price from Y. In this case, there is a tacit ratification by X. The requisites for express ratification are the same as those for implied ratification, except that the former is expressly effected.
According to Article 1394, ratification may be effected by the guardian of the incapacitated person. Examples of incapacitated people are minors or those who have Down syndrome. Ratification means approval or confirmation between two parties. When it comes to a contract entered into by an incapacitated person will only be ratified with the help of his or her guardian or the injured party himself. For example, if B is a minor and C is an adult, they've decided to enter into a contract whereby B will sell his Rolex watch to C. The contract will only exist when the guardian of B given his approval.
Article 1395 states that ratification does not require conformity of the contracting party who has no right to bring the action for annulment. So ratification, it is a unilateral act by which a party waives the defect in his consent. This article simply says that the consent of the guilty party is not required, otherwise he can conveniently disregard his contract by the simple expedient of refusing to give his conformity. So in here, the one who caused the consent personally or through a third person is not allowed to file a case of annulment. The innocent party also has the prerogative to annul or not annul a voidable contract. For example, A is the owner of a famous hardware in Muntinlupa. He rented the house of B to become one of his bodegas. C bought some materials that he needed for the construction of his own house to A. Since the other materials are in the warehouse of B, in which A has already rented, therefore, the consent of B is not needed for the delivery of the materials that C has needed.
Article 1396. Ratification cleanses the contract from all its defects from the moment it was constituted. There are retroactive effects. This article extinguishes the right of action to annul, which has already been mentioned in Article 1392. Otherwise, legal purification and its being made as a regular and untainted contract. In other words, to make the contract valid from its inception subject to the prior rights of the third person that are not prejudiced acquired before the ratification. Here is the example to be clarity in this article. B forced S to sell the latter's horse. Later, the horse gave birth to a colt. If S should ratify the contract after the birth of the colt, who is entitled to be colt? S, because ratification has a retroactive effect. It validates the contract from the date of its execution. If the horse had been sold by B to C, who acted in good faith, the subsequent ratification by S of the sale to B cannot prejudice C. The sale to B is valid until annulled by a proper action in a court.
Article 1397. The action for the annulment of contracts may be instituted by all who are thereby obliqued principally or subsidiarily. However, Persons who are capable cannot allege in the capacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused mistakes base their action upon this clause of the contract. There are two different requisites are required to confer the necessary capacity to bring an action for annulment of a contract to it. The number one is the plaintiff must have an interest in the contract. Number two, the victim and the not guilty party or the party responsible for the defect is the person who must assert the same.
Article 1398. An obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract, with their fruits, and the price with its interest, except in cases provided by the law. In obligations to render service, the value thereof shall be the basis for damages. Mutual restitution upon annulment. In principle, if a contract fails to fulfill its obligations, the parties are required to return the deal's fruits and price, plus any accrued lawful interest, to one another, unless the law recognizes basic factors that will impede such repayment. Who may invoke restitution? Only the relationships between the parties to the contract. A third party, who is not a party to the real contractual relationship, cannot benefit from this clause. When contract is not covered, one of the contracting parties receive anything for which he has not compensated the other. It is only fair that he restore the sum by which he has unjustly profited. If the parties filled reciprocal prestations, which they could recompense one another, the excess amount may be paid to the relevant party. For example, the mutual restitution cannot be complete if a lease agreement is made for a piece of land for a year, with the land transferred and the rent paid in advance for the entire year. The lessor should only be required to return the amount of rent which is appropriate to the remaining 8 months when the lessee is obligated to send back the property.
Article 1399. When the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution, except in so far as he has been benefited by the thing or price received by him. The incapacity mentioned in the above article is any form of incapacity or mental debility and not merely a minority. An incapacitated person is typically given preference by the law and does not require their abilities to be restored. The parties are expected to restore or return everything in line with the provisions of the contract, including interest if it is found to be void. Required to return the money made from the thing sold or from the received price must be returned if one party's incapacity renders the contract void. Restitution by incapacitated person. In general rule, the incapacitated person will be required to make restitution. In circumstances where the minor obtained the thing or price as a consequence of a contract that is totally and exclusively voidable due to his incapacity, the minor must make a restoration since he has gained from it. If they did not gain anything, he is not obligated to make a restoration. Exemption provided in Article 1427. This is an exception to the general rule of mutual restitution, only insofar as he benefited by the thing or the price he received is incapacitated person obliged to make restitution. Example, a sister and minor brother lent money to a more company. The fund went toward providing for the minor. The youngest promissory note, however, which demanded payment of 20,000 was signed for 2 years. The minor were compelled to refund the funds they got from the amor since they benefited from their usage of them after they ended and were voided by the court. An incapacitated person receives something from a minor and uses it for his or her gain. They are required to give it back unless they receive it in good faith while fulfilling the minor's natural obligation.
Article 1400.
Whenever the person obliged by the degree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return the fruit received and the value of the thing at the same time of the loss with interest from the same date. In this article, mutual restitution is in effect, but the object that is supposed to be returned was lost. What will happen if the object lost was his fault? Then he shall return the fruits that he received, the value of the thing at the same time of the loss, with interest from the same date. What will happen if the object loss is not his fault? Then that person is not obliged to return the thing. For example, S sold his plow and Carabao to B. And the petition of S, the contract was annulled by the court, but the Carabao died in the possession of B through his fault. Under Article 1400, B must pay the value of the Carabao at the time of its death, with interest from the same date. If the Carabao had given birth, the young must also be delivered as the fruit of the said animals.
Article 1401. The action for annulment of contracts shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has the right to institute the proceedings. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action, unless said loss took place through the fraud or fault of the plaintiff. In this article, the loss of the thing while in the possession of the party who can annul the contract. First, due to his fraud or fault. In the first paragraph of this article, simply stated, the person who has the right to file for annulment will not be able to return the item. For this reason, due to his fraud or fault in the case of annulment, his ability to bring the contract annulled is extinguished. Second, due to a fortuitous event, Article 1402 applies. However, in the second paragraph, the right of action is based upon the incapacity of any one of the contracting parties. The rule will be the same as what is mentioned in the first paragraph, regardless of whether the cause of action based on incapacity or not. For greater clarity, consider this example. A was forced by X to enter into a contract of barter whereby X exchanges his phone with A's collection bag. If the phone is lost due to fraud or the fault of A, under Article 1401, A's right to file for annulment of the contract is extinguished. Note, the action for annulment should be extinguished only if the loss is through the fraud or fault of the plaintiff. If the loss is not due to his fraud or fault, this will be discussed and applied in the Article 1402.
Article 1402. As long as one of the contracting parties does not restore what in virtue of the decree of annulment he is bound to return, the other cannot be compelled to comply with what is incumbent upon him. In this article, a reciprocal obligation of reparation is generated when a contract is annulled. One party's return of the items required by annulment decision may be viewed as an essential requirement for the other party's fulfillment of his obligations. If the party is unable to restore what he is required to return, there won't actually be an annulment and the other party cannot compel the other party. For example, Lark and Jessie made a deal under which Lark promised to make a painting of Jessie's mother, but it came out that Jessie is only 14 years old, making him unable to sign a contract. The agreement was declared invalid. The painting had to be returned by Jessie, and Lark had to reimburse the money that Jessie had used to purchase it. According to Article 1402 of the new Civil Code, Jesse cannot be forced to return the painting because Clark did not return the money.
The first case study to be discussed is Sing-Song versus Isabella Somil's case. General Register Number L-27343, 88 Supreme Court Reports, annotated 623 on February 28, 1979. Apelis are Manuel G. Singson, Jose Belzuns, Agustin Eton Say, Jose L. Espinos, Bacolod Southern Lumber Yard, and Open Esteban Incorporated. While defendants are Isabella Somil, Margarita G. Saldajeno, and her husband Cecilio Saldajeno, Leon Garibay, Timoteo Tubong Banua, and the Provincial Sheriff of Negros Occidental. Defendants, Margarita G. Saldajeno and her husband, Cecilio Saldajeno. Isabella Sawmill is a partnership created through a partnership agreement. A motor truck and 2 tractors were sold by the plaintiff to a partnership. Even after a demand was made, the partnership was unable to pay the entire debt. The partnership was not terminated when one of the partners left it. Rather, the 2 surviving partners continued it under the same firm name by signing a memorandum agreement made in Saldajeno. The assignment of rights with chattel mortgage that the withdrawing partner and the surviving partners entered into is also being challenged by the plaintiffs. According to the appellants, since the chattel mortgage has been judicially approved and foreclosed, it cannot longer be declared valid. The issue found was whether or not the dissolution of the partnership results from one party's withdrawal and the chattel mortgage that cannot be revoked. It does not appear that the withdrawal of the partner was announced. With that, appealees and the public in general had a right to expect the remaining partners could be enforced against the properties of the partnership. The withdrawing partner cannot be relieved from her liability to the creditor of the partnership due to her own fault for not insisting the liquidation of the partnership. Technically, the partnership was not dissolved by the withdrawal of one of the parties. Through her act of entering into a memorandum with the remaining partners, she misled the creditors into thinking that they were doing business with the partnership. Hence, based on the order of the lower court ordering the withdrawal partner to pay the plaintiffs, she is thus entitled to reimbursement from the remaining partners.
Velarde et al. Versus Court of Appeals. The case study to be discussed is Mariano Z. Velarde and Avelina D. Velarde versus Court of Appeals, case GR number 1036436, SCRA 56 July 11, 2001. The facts about the case: David Rimundo is the owner of a parcel of land. He executed a deed of sale with assumption of the mortgage with a balance of 1.8 million, which was entered by Avelina and Mariano Velarde, plaintiffs in the case. The plaintiffs agreed to the negotiated terms and paid the BPI Bank the monthly interest for 3 months. Upon the BPI Bank's pending approval of the application, they were required to continue paying the monthly interest. However, they were advised the bank that their application for assumption of mortgage was not approved. Moreover, the plaintiffs are not going to continue any payment. The defendant wrote a letter to notify the plaintiffs for non-compliance of their obligations, and the plaintiffs responded in a letter that they are willing to pay the balance in cash and also subjected to several conditions, new conditions. With that, the defendant canceled or rescinded the deed of sale. As a result, the plaintiffs filed a complaint against the defendant, which was consequently dismissed by an outgoing judge, however was reversed by the assuming jurisdiction in their motion for reconsideration. The Court of Appeals reinstated the decision to dismiss. The problem found was whether or not the non-payment of the mortgage obligation of the petitioner resulted in a breach of contract. The answer was yes. There is a breach of contract from the non-payment of the petition. Under agreed contract of the parties, the petitioner needs to pay the monthly interest, and upon the bank pending approval of the application, they need to continue paying. However, the bank disapproved their application and the petitioner stopped paying the said monthly interest and also their own obligation to pay the full contract purchase price, which caused a breach of contract.
This case is under Article 1390 between Oisolim versus Benito Tan on Chuan. These are the facts of this case. Santiago Pastrano, a Chinese national, was married to Candida Vivares. At the time of this union, Pastrano and Vivares had two daughters, Francesca and Concepcion. Pastrano possessed very little real estate, and the sizable legacy he left his heirs after his death was acquired through his marriage to Vivares. Pastrano returned to China and began an affair with Chan Kig. He went back to the Philippines and never saw Chan Kig again, but he did get letters from her informing him that his son Oisolim, who is the current plaintiff, had been born. Santiago made sure that his son received the majority of his estate in his will despite the fact that he died without ever having met him. Santiago believed that his son was the only child he had. A number of cases were brought up against the state's distribution. Francesca and Concepcion contend that due to Chan Kig's marriage to their father was null and void, Oisolim, their son, shouldn't be entitled to the money provided to him by law. Oisolim, who was still minor, agreed to give Francesca all of his rights, titles, and interests in the state of Santiago in exchange for payment, and it was approved. In order to revoke and invalidate the agreement under which he had sold and transferred his part in the estate to Francesca Pastrano, Oisolim filed the current case in the Court of First Instance of Cebu after he reached legal age. He claimed that a group of people colluded to exert undue influence on him, exploited his youth, passion, and inexperience, and misrepresented important information about the value of the property and interest in question, among other things, in order to persuade him to sign the instrument of cession. The issue of the case is whether or not Oisolim's contract shall be considered null and invalid due to his minority. The answer is no. The ability of a minor to cancel a contract they entered into while still minor is subject to two requirements. First, the cancellation must be elected within a reasonable period of time after reaching majority. And the second, the minor must return all consideration that was in their possession at the time of their decision to cancel. Any disposition of the consideration after reaching majority status implies an affirmation of the contract. The assumption of the Supreme Court is the plaintiff might have had a right to annul the contract on the ground of minority, but his action fails. Because with the full knowledge of his right in the premises, he failed to disaffirm his contract within a reasonable time after reaching majority. And because he not only failed to tender or offer to produce and pay the consideration in esse when he reached majority and when he filed his action, but proceeded after such events to demand, collect, and dispose of such consideration when, according to his own statement under oath, he had no other funds with which to make reimbursement. The Supreme Court stated its opinion that the trial court is without error and it is therefore affirmed with the cause of both instances.